Hello everyone and welcome to this webinar organized by Lydian, a webinar on cloud contracts. What are the key issues? My name is Bastiaan Bruinooms. I am a partner at Lydian and leading the ICT and data protection practices at Lydian. Maybe before we start, a couple of practical things. First of all, the slides can be downloaded in the panel at the right-hand side of your screen. That's the first thing. Second thing, after the seminar or after the webinar, you will receive from GoToWebinar a certificate of attendance that will come later then. Third thing, during the webinar, in order to check presence and attendance, we will have 2 poll questions where you will get 20 to 30 seconds to answer to. So please pay attention to these 2 poll questions. And then last but not least, if there are any questions, please feel free to use the chat function. Also at the right-hand side in the panel, at the right-hand side of your screen. We will try to answer questions at the end of the webinar, but although I see that the agenda is very full, it may be that we will have to come back to you later by email, but do not hesitate to ask any questions that you may have during this webinar. So the topic of this webinar is cloud contracts, and we will have first a short introduction that I will give on the concept of cloud contracts and cloud itself. Secondly, I will go into the key issues, in my opinion, in every cloud contract. What do you need to pay attention to? And then lastly, I will conclude with what I would call a practical approach to reviewing and assessing cloud contracts. First of all, what exactly are we talking about? Well, we are talking about the cloud. What is the cloud? The cloud is, in fact, as defined by the National Institute, NIST. It has been defined as a model for enabling ubiquitous, convenient and on-demand network access to a shared pool of configurable computing resources that can be rapidly provisioned and released with minimal management effort or service provider interaction. There are, in fact, 5 essential characteristics to the cloud. And those characteristics, and I wanted to start with that because it's very important to know the technology and to know what exactly cloud is to be able to assess cloud contracts. So I wanted to start with this. What are the essential characteristics? First of all, it's an on-demand service. It's the customer that requests some IT resources from the cloud vendor. It is based on availability of resources, computing resources over the internet, over a network. So it's based on broad network access. It is also based on resource pooling, and that is very important in a cloud context and also for reviewing cloud agreements. It is really a trade-off between, on the one hand, having your own on-premise installation and on the other hand, benefiting from economies of scale by pooling together different IT resources and making use of pooled IT resources. It is also characterized by rapid elasticity, meaning that the customer can quickly add resources or give up certain resources that the customer does not need anymore. And last but not least, it's also a service that is perfectly measurable in terms of, for example, availability, response rates, reaction rates, and so on. And the way that the cloud is being put into practice is basically through 3 cloud service models and 4 cloud deployment models. The cloud service models, just to resume or to summarize, it's you have infrastructure as a service, you have platform as a service, and you have software as a service. And if you see the pyramid here, you see very well what you get for each of those services. If you take infrastructure as a service, that is really only server, storage, and network. If you take platform as a service, you get server, storage, and network, but also an operating system and an application stack. Those two, platform as a service and infrastructure as a service, who are the users? Well, it's for the infrastructure, it's most of the time infrastructure and network architects. And for the platform as a service, it's application developers. So not really your end users. Where do the end users come into play? It's when we are talking about software as a service. There you get really an application together with the servers, the storage, the network, the operating system, the application stack, but you get access to a specific application, and there it will be mostly used by the end users, those who are using the application. And then if you look at the cloud deployment models, you can distinguish between a private cloud, which is really, in fact, nothing more than what we had in the past. You have your own computing resources somewhere in a data center. You have a community cloud, meaning that you are sharing with a community of organizations with the same characteristics, for example, or forming part of the same group, a specific community cloud. You have a public cloud, which is really the cloud as most people know it, meaning that your data are just in the open, or just in the cloud, and are on servers that are being used by a multitude of users or tenants. And then you have, of course, many forms of hybrid cloud, where there is a combination of public cloud, private cloud, and or community cloud. Now, this is important to understand and to be able to review cloud contracts. And what is so specific about cloud contracts? Well, first of all, one could say it's not really a software product. You are not obtaining a software license. On the other hand, it's also not really a service contract, because nobody is really doing something, performing a service for you. But you know that most of the time we speak of software as a service, infrastructure as a service, and so on. So there is some notion of service, but it is something in between. What you get when you enter into a cloud contract is basically access to computing resources, an application, an operating system, a platform, servers, storage, and so on. The consequence of this is that the typical on-premise agreements that we know from the past are often not really well adapted to this kind of cloud contracts, and are not really a starting point. In fact, cloud contracts resemble more hosting, strategic outsourcing contracts than what we know from the past, the typical software license agreements. What is also specific about the cloud is that we are working in most of the time with contracts of adhesion. In Dutch, toetredingsovereenkomst, in French, contrat d'adhésion, meaning that you have a contract that is being proposed by the vendor, and this is it, and there is very little room for negotiation. What we see in the market is that large vendors, they may be willing to negotiate to a certain extent if it concerns a large deal. Smaller vendors, especially startups with cloud applications, they are more willing to negotiate because they are starting to build up their business, and they may be more willing to amend their standard terms and conditions. We also see in the market that some of the larger and more sophisticated customers are developing their own form of cloud agreements, which they are trying to impose upon vendors, which is, of course, not always very easy. Now, the question, and this is the basic question throughout this entire webinar, the question is then, what do you do? So you have a contract of adhesion, you have little room for negotiation, you are working with a standardized contract, your old on-premise agreements do not really fit well in a cloud context, and customization is not really easy, it's rather difficult because of the multi-tenant nature of the services and the fact that this is being sold as a commodity, something that is there. This is what you get, and you take it or you leave it. So this was my question when preparing this webinar. What do you want to focus on in these contracts? And I've identified about 13 issues, key issues that I think are worth considering. Let's start with the first issue. The first issue is the contractual framework. And this is really an issue that I see all the time. The contract that you may receive from your vendor is probably a subscription agreement of a couple of pages, 5 pages, 8 pages, something like that. But if you look deeper into the contract and you go and read the contract, you will see that reference is made to a multitude of other documents, which also form part of the contractual framework. Think about terms of service, so-called general terms and conditions, product and service descriptions, the service level agreement, which is often separate, the privacy policy, the acceptable use policy, the data processing agreement, various annexes on security. Sometimes security is regulated per service or per product that is being sold or bought by the customer. So your first task, I think, when reviewing a cloud contract is really getting to know what you are really signing up to and making an inventory of all those documents that constitute the contractual framework. And often you will see that you have been sent a document of a subscription agreement of about 8 pages, but when you have inventorized everything and you've printed it out, you easily get to about 100 pages of documents which all form part of the contractual framework. There are 2 things which are important there. First of all, that you look at what is the binding nature of these documents, because some documents may be just advertising, flyers, and so on, which have nothing to do with the contract itself. So what is the binding nature of these documents? And then secondly, what is the precedence between these documents? And you may want to have this regulated very specifically in the cloud contract. So that's the first issue. Second issue that we always encounter when reviewing cloud contracts is the issue of so-called unilateral amendment. Unilateral amendment, URL terms, and online terms. What is the problem? There are various problems. The first issue is that we see very often most contracts provide for the right of the vendor to amend the contract and the services unilaterally. So meaning you sign a cloud agreement today and tomorrow the vendor may say, well, here are our new terms and conditions. Here is our new service description. Oh, by the way, you know, we were working on a new SLA. This is the new SLA. You will, as a lawyer, you feel immediately that this is very difficult to accept. The normal situation, as we know it as lawyers, is when you sign a contract, this is considered to be the law between the parties. So that's the first issue. The other issues are very similar. The second issue is that what you find often in these contracts is reference to online additional terms and policies. I refer to the first issue I discussed with the contractual framework. Again, if you are referring to online additional terms and policies or documents in general, well, these are things that are not static. They may change over time, and they probably will change over time. So again, same issue. Third issue that you often see in cloud agreements or in cloud context in general is that you have signed a contract as a company. You start using the application, for example, and the end user, before he can access the application, is being asked to agree to different online disclaimers, online additional terms and conditions, and so on, which often void to a certain extent the contract that you have signed. This is also problematic. These three issues are also problematic often from a regulatory point of view, and I will come back to that at the end of the presentation on the regulatory issues. But often regulators ask that you can present to them a contract that is the law, or that will be the law between the parties for the next 2, 3, 5 years, which is not the case if the contract can be amended at will by the vendor. So what do you do, or what can you do? You can, first of all, let's exclude additional click wrap, shrink wrap, click through online terms. That's easy. You can also consider excluding unilateral amendments by the vendor, but you will often find out that this is very difficult, nearly impossible. So what is the practical solution? Make sure that there is some limit on the changes made by the vendor. Limited to commercially reasonable modification. Try to prohibit modifications that are materially detrimental, for example, which are materially diminishing the nature, the scope, or the quality of the service. For example, lowering the level of service in the SLA could be considered as that. And provide for a notification obligation in case of changes, and possibly a termination right for the customer. But of course, know that this termination right, I think you should provide it in the contract, but it's rather theoretical. You know that going to the cloud is quite easy, but leaving the cloud for an issue like this will not be very likely done. The third important thing that you have to look at in the cloud agreement is the service level agreement, because basically what you will get under the cloud contract is what has been described as standard of service in the service level agreement. And this is a task that needs to be done in collaboration between, on the one hand, your IT manager, your IT personnel. They can look at the content of the service level. They can assess whether 99.9% availability is sufficient, or whether they need 99.90, and so on. That's their task. Your task as a lawyer is to look at how this all has been written down, and whether this is sufficiently clear and sufficiently binding between the parties. What needs to be in an SLA, the minimum is, first of all, what are the service levels provided? And the most important service level in any cloud contract is availability. I said at the very start that this is all about access to a certain cloud, to certain IT resources, and access that can only be measured in availability. How much is the availability guaranteed within the contract? Next to that, you have a number of other service levels which are very relevant, which is, for example, response and resolution times. If there is an issue, an incident, a problem, you want to know how quickly will the vendor be on it? That's the response time. And how quickly will it be resolved? That's the resolution time. So you will want, as a customer, to have some guarantees there, and maybe you want also some guarantees on disaster recovery, like disaster recovery time objectives. So first of all, what are the service levels? What are the exceptions to the service levels? For example, service windows, when things are being done on the system may not be available. So when does this take place? Is this clearly defined? Are you being notified on beforehand, and so on? How is the service level being measured, and how is it being reported? As I said, these are things to look at both from an IT perspective and from a legal perspective, and legal should look at how it is being how it has been drafted, whether it's sufficiently binding and clear. There are also some typical legal aspects in an SLA, and that is the remedies. What is your remedy as a customer if things go south? You probably will have service level credits, so you will receive some penalties from the vendor. Question is this a sole and exclusive remedy? If it is a sole and exclusive remedy, remember that even if the damages that have been incurred by you as a customer are much larger, you will be limited to receiving those service level credits. Another issue to consider is, and to check is there a possibility to terminate the contract for repeated breach of SLA? This should, from a customer point of view, again, be provided. And then last thing to check from a legal point of view is, what is the relationship between the SLA on the one hand and the disclaimers of warranties on the other hand? I will come back to the warranties and the disclaimers later in this presentation, but the issue is that most of the cloud contracts provide for extensive disclaimers of warranties, saying that this is a service that is provided as is, if and when available, without any guarantee of uninterrupted service, and so on. So then you need to make sure that your disclaimer of warranties does not void the SLA with, for example, 99.9% availability that you have agreed to. That is again a legal issue. Fourth issue that I wanted to tackle is data ownership. And in fact, when I'm speaking about data ownership, I'm already making a mistake, because data ownership is clearly a misnomer. You cannot own, at least not under Belgian law, you cannot own data or information. Most intellectual property rights attach to the form of data. So you can have, for example, a presentation with data, containing data, which is protected by copyright. But the data itself, they are not protected by this same copyright. Belgian law only recognizes ownership of intangible items when this has been specifically provided for, and these are the IP rights. And those IP rights do not contain any rights of ownership to data or information. So what is it about rather? Well, it is rather about control over the data. It's your data that will be in the cloud. So what you want to do as a customer is to make sure that you maintain control over your data. That means that you specify in the agreement what can be done with the data, by whom, and when. And one of the issues that needs to be tackled here and that needs to be checked in the agreement is, what can your vendor do with your data? There are different issues or different purposes for which your vendor would be willing to use your data, for example, for service improvement, but also for marketing purposes, for statistics, for performance data. So there the question is really, what do you allow the vendor to do with your data? It is up to the customer to decide yes or no, and in what form and under what conditions. And again, there is a trade-off to be made. Remember that most of the clauses speak about using your aggregate data. Remember that aggregate is not exactly the same as de-identified, and de-identified in turn is not again exactly the same as anonymized. Remember also that when you permit the vendor to make use of certain of your data, if this concerns also personal data, that you comply with GDPR, but I will come back to that in a few minutes. But it's clear that you need to have in your contract a specific clause dealing with control over data. Usually it's called data ownership, but that's probably more a legal theoretical point to be made. Before we go to the next part, a poll question: the cloud vendor may be a data controller with respect to the personal data that the customer stores in the cloud. Is this correct or is this wrong? Okay, we have the results of the poll. 58% says that it is correct, 42% says that it's wrong. Let's look at this question in more detail. And this is the issue of data protection and data security. First of all, remember that data protection and data security are not exactly the same. Data protection is about personal data. Data security is about all your data, all your customer data, also the non-personal data. Data security is also only one part of data protection. It's only one of the 6 principles that you find back in Article 5 of the GDPR. The thing with cloud computing is that when you go to the cloud, your data will be in the cloud. You give up to a certain extent control over your data. Your data will be with the vendor. So you will want to ensure 2 things. You will want to ensure, first of all, that whenever there is personal data involved, that you comply with data protection. That's the first issue. And the second thing that you want to do, you want to also protect all your other data, because these can contain trade secrets, competitive information, information about your business, about your clients, about your customers, your suppliers, and so on. So also that you will want to protect. And so data security is in fact much broader than only data protection. But at the same time, data security is only one aspect of data protection compliance within the meaning of GDPR. It is a key issue within cloud contracts because of the fact that you give up control over your data to a certain extent. Data security is really a key issue. The specific thing in a context of cloud is that it will be very difficult, if not just impossible, to do as you did with your on-premise contracts. When you contracted with a vendor, usually the large company, the customer, came with a security document, 100 pages, 150 pages. This is how we want you to protect our data when you provide us services on-premise. And we want to have the systems configured in this way. This will not be possible in a cloud context because in most of the cases you will be making use of an application that is multi-tenant. There are thousands of users of this application, and in fact the vendor can just practically not take into account any of the requirements of, or all of the requirements of each of these customers. So rather than imposing your own IT security guidelines or rules, it will be up to your CISO, your corporate information security officer, or your IT manager to check what is the security being offered for the data and to see whether this fits with your security or with your risk appetite, yes or no, and to accept it or not to accept it. There may be, of course, a number of options. You can, for example, opt for specific encryption, additional services in the field of security, but you will be limited to what is being offered by the vendor, and it is much more a question of assessing what is on offer by the vendor and seeing whether you will accept this or not, than really imposing your own IT security requirements. Now, if we look then at the issue of data protection, I think there are 3 issues, and that's where we had this question about data controller or data processor. Indeed, the vendor can take the role of a data processor or the role of a data controller. In a classic situation, in all cloud agreements, the vendor will be mainly a data processor, a party that is processing your personal data on your instructions, on your behalf. What does that mean? I will not go into detail here, but you know that Article 28 of the GDPR provides for the obligation to ensure that there is a data processing agreement in place. You will need to make sure that also you have a clear description of the processing in the annexes to the data processing agreement. This is a requirement under the GDPR. And you will also need to make sure that there are technical and organizational measures to secure your data, but this is coming back to the previous slide. And there again, the issue will be whether you accept, maybe with some modifications, the security that is being offered by the vendor or not. What is important here, and that's the last line on this slide, again, we come back to this right of the vendor to change the terms of the agreement in some circumstances. Indeed, the vendor may also be required or may be willing to change from time to time the security features. That may be acceptable, and that may be also good practice to the extent that the security gets better, but make sure in your contract that what has been agreed on day one is the minimum level of protection. This is what you were comfortable with, and this is at least an equivalent level of protection should be maintained. The vendor may in certain cases also be a controller. When use is made of customer personal data for own purposes of the vendor, then the vendor will be a controller of the data. That can be for diagnostics, that can be for service management, can be for service improvement. Let me just give you one example. A payroll services provider that offers a cloud application to enter all your wages and all your data about your employees may be willing to use your data to draft and publish a report, a yearly report on the evolution of wages in Belgium or in your specific sector. The question is again here, whether you allow this or not. You are the data controller, it's your data. So it's up to you to decide whether or not to permit this use by the vendor. Remember, however, that as you are the data controller, you are also responsible for transparency towards the end users. And you will also see often that in situations where the vendor reserves the right to use your personal data or your customer data for certain purposes, that they will try to shift a lot of the responsibilities of compliance with GDPR that lie with them, the vendor as a controller, to you as the organization that has most contact with the end users. So don't forget that if you permit it, make sure that transparency is addressed and also that legal ground is being addressed. Last but not least, the issue of international transfers. If we are talking about cloud, many of the cloud providers are established in the US or at least have ties to the US. So you immediately get into the issue of government access to data. It's really the issue of the famous Schrems II decision. So very important in the contract to know where your data will be. That's the first question. And the second question is, even if they remain within the European Union, from where are they accessible? In many cases, there are possible accesses from other countries, for example, for 24-hour around the clock support, for example. Your data may be available at some times in India, or from Africa, or from the Philippines, and so on. So whenever you have a situation where your data will either be located outside the EU or will be accessible from outside the EU, you have an issue of international data transfer. You can make use of the standard contractual clauses. You know that these have not been invalidated. These have even been improved by the European Commission. But know at the same time that standard contractual clauses alone will not do. As a data controller, as a customer, you will have the obligation to perform a so-called transfer impact assessment and verify whether supplementary measures should not be taken in order to protect the data whenever they are outside of the European Union. So this, in a nutshell, I will not go into the detail here, but in a nutshell, these are the issues on data protection and data security. Warranties and disclaimers. As I already said, many of these cloud contracts contain broad disclaimers of warranties. Service is provided as is, if and when available, without guarantee, no guarantee of uninterrupted service availability, and so on. What would you need as a customer? I think you would need at least 4 warranties. First of all is a performance warranty, making sure that the service performs as advertised or announced or described or specified in the agreement and the documents that form part of the agreement. Second, a compliance warranty, stating that the supplier, the vendor, complies with applicable legislation and regulation. A non-infringement warranty, making sure that the service that you are using is not infringing on the IP rights of a third party, and a malware or virus warranty, making sure that the vendor does all or takes all reasonable steps to avoid viruses or other malware from being introduced into the system. Again, as I said in the beginning, make sure that the disclaimer of warranties do not interfere with binding obligations, like, for example, SLAs. So your SLAs should be a clear exception to any disclaimers of warranties that are included in the contract. Then some words about liability and indemnities. You will see that, and you will have noted that most cloud contracts provide for exclusions of liability and limitations of liability. I would say from a customer point of view, be realistic about liability and take also into account the fees and the charges that are paid and payable. A couple of issues. First of all, indirect and consequential damages. Often I get the question, is this acceptable or is this not acceptable? Shouldn't we make a remark about the fact that indirect and consequential damages are excluded? Well, to be very honest, when you enter into an on-premise IT agreement, it will most of the time, unless you are working with very small vendors, it will most of the time also include a exclusion of indirect and consequential damages. So it's not a thing to make a lot of fuss about. What you should do, however, is check whether indirect and consequential damages is appropriately defined and does not contain direct damages that are obviously direct. It may also be interesting to provide for a clause that defines to some extent and that gives examples of what is then considered as direct damages. And then the last issue here is check what is the fate of loss of data, because in many of these cloud contracts you will find that loss of data is being considered as indirect or consequential damages, and from a customer point of view this will not be acceptable. So make sure that this is outside of the scope of indirect and consequential damages and that there is something in the contract about loss of data. This may be unlimited liability, very unlikely. This may be limited liability by the normal liability under the normal liability caps, or it may be a special system. And what you find often in these contracts is that, for example, the liability for loss of data is being limited to the costs of putting back the last backup. But there, one thing to check, who is responsible for the backup? It's not because you have a cloud contract and your data are with a cloud vendor that this cloud vendor is automatically responsible for making a backup. It may very well be that you are yourself responsible for making a backup, or that you have to contract additional services to ensure that there is a backup being made of your data. So check this, please, because I've had situations where things go wrong and customers thought that they had backup services included and it was clearly excluded. They were themselves responsible for the backup. About the liability cap, you will know that it is often linked to fees and charges payable. I think that is generally the rule. That is also what is generally accepted in the market. However, consider, for example, a minimum floor or floor to the liability cap, especially for the first months, because if you refer to fees paid over the last 12 months, for example, if you are in the second month, your liability cap will be very low. Also, please do not ask vendors to take on disproportionate liabilities. That's what I said in the beginning of this little chapter. Be realistic and take into account the fees that are being paid for the services. Where can you negotiate higher fee caps or maybe even unlimited liability? That's compliance with data protection legislation. I see it more and more. That's really an issue where negotiations take place. Secondly, breach of confidentiality, security of the customer data, and IP infringement by the vendor. Check also the force majeure clause. Force majeure is normal to have it in a cloud agreement, but again, it's the definition of force majeure that is important, and check whether it is not overly broad. For example, sometimes you find statements saying that force majeure includes non-performance by third-party suppliers or failure of the electricity supply and so on. These are things that are all subcontractors and that should not be regarded as force majeure. Then about the indemnities, I think indemnity, what indemnities can you expect or should you have from the vendor? I think two. First of all, third-party IPR infringement. Although, and that's the note I've put next to it, although this issue may be rather moot, because in fact, everything is on the systems of the supplier, of the vendor. So the chances that you as a customer will get a claim for third-party IPR infringement are really, really very, very small. The other indemnity that you would want to negotiate is inappropriate disclosure of your data or data breach. So again, breach of confidentiality. You will also see that most of these contracts provide for indemnities by the customer, and there it is acceptable to have such an indemnity. However, make sure that this relates to things which are under your control. Meaning that, for example, if there is an indemnity for non-compliance with the acceptable use policy, they should be limited to persons that are under your control making use of the system. We come to the second and last poll question, which is the following. It is important that the cloud contract grants a clear IP license to the customer to use the software. Correct or wrong? Okay, so about 65% of the people, of the attendees say that this is a correct statement. I'm very sorry, but this is in fact a wrong statement. Indeed, IP clauses in a cloud contract are one of the most misunderstood clauses in this type of contracts. They are indeed, the whole issue of IP is completely different from the issue of IP in on-premise IT contracts. Do you need a license? Well, software as a service is not a license. You are not copying code to your own personal computer or to your servers. You are not installing a software on your systems. So you don't need a license. The only thing that you get is a right of use or a right of access. And this is also the way that most of these contracts have been drafted. So please do not expect a software license in a cloud contract. Also, do not expect a perpetual license. I've had discussions with customers who said, well, we are going to pay over 5 years this amount of money. At the end, we want to continue using this software. No, this is the whole model of cloud computing. You pay on a subscription basis. The day that the contract is over, you have either to renew the contract or you have to move to another platform or to take things internally within your organization. That is an important thing, and it is also important for softwares or applications or resources which are business critical or in a public procurement context. The second question that we often get is, what about the ownership of configurations and custom development? And again, there, most customers come from the context of the on-premise IT contracts, and they say, well, we need to be the owner of everything that is being configured for us and everything that is being developed for us by the vendor. For the vendor, it is very difficult to make a distinction between configuration on the one hand and custom development on the other. That is the first thing that you should take into account. Second thing is, this is often multi-tenancy, meaning that there are thousands of users making use of the same software solution or the same IT resources. So very difficult, if not impossible, for the vendor to grant exclusive IPR rights to one of his 1,000 customers. So indeed, the vendor expects to be able to continue to own custom configuration. As regards custom development, where there is really development of new pieces of software, really coding of software, there may be room for negotiation, and maybe the customer can indeed get the IPR rights in those custom developments. But again, what is the use of it? Especially if you are moving to another platform, probably all what has been developed for this first platform will no longer be of use to you whenever you leave this platform. What are the things to look at in term and termination? Very short. First of all, contracts will usually be for definite duration, 1 year, 2 years, and so on. They will be able to be renewed, so you need to check the renewal conditions. This is an issue of contract management, of course, also to make sure that your contract management people keep an eye on the dates at which the contract is being renewed and when you can eventually or possibly terminate the contract yourself. Check the conditions for early termination for convenience by the customer and check whether there are termination fees applicable, yes or no. And then last issue here, or penultimate issue here, check the conditions for early termination for convenience by the vendor. And the vendor may reserve the right to terminate the contract in some circumstances for convenience. So check here whether this is acceptable or not, and especially the following things. First of all, do you have a notice period that is sufficiently long for you to migrate? Consider thereby the business criticality of the application or the resources and the time needed to migrate, and consider also the regulatory requirements. As I said, I will come back to that later. Last issue to be looked at in term and termination is the so-called suspension. Many of those cloud contracts will provide for a right for the vendor to suspend the service, for example, in case of non-compliance with the acceptable use policy. This may be acceptable from a theoretical point of view, but make sure as a customer that you limit this to very limited circumstances which are sufficiently serious, that these circumstances are clearly described, well defined, that you get prior notice and a remediation period, and that in case of suspension, that the suspension is limited to those end user accounts that have breached or violated, for example, the accessible use policy, but not for the entire company or organization. In relation to termination is also important lock-in, exit, transfer assistance, and data portability. What I mean, and I've said it before, is that going to the cloud and entering into a cloud agreement is very easy. And everyone will be happy when the contract is signed and we're going into a new age, we're going into the cloud, we're renewing our IT infrastructure and so on. We're making use of a number of very well-known vendors and so on, everyone will be happy. However, the day that you have to leave this cloud, all your data will be in the cloud with the vendor, and it may be often a nightmare to get out of the cloud again, especially if you have not thought about this situation when you entered into the contract. And that is really the thing to note here. When you enter into a cloud agreement, one of the first things that you have to think about and that you have to deal with in the contract is to make sure that you know what happens at the end of the contract. What are your rights at the end of the contract? And the whole issue is due to two things. First of all, a lack of interoperability for the time being, and often also a lack or diminished data portability. So what do you need to consider? You need to consider, first of all, your right to recover and migrate your customer data. So you need to know what data can I bring back, what data can I get back from the supplier. Is there a grace period, or is it so that the supplier or the vendor will, at the end of the contract, automatically delete my data? That you will want to avoid. You will want to have a certain period that you can migrate your data after the contract has been ended. And what is the form of export of your data? These are three important questions. What other issues do you need to consider? First of all, do you need any assistance from the vendor? You may want to have some assistance from the vendor at the time of migrating. You want to regulate that in the contract and also provide for the financial conditions or the commercial conditions for receiving such assistance. Another issue is data deletion. Of course, this is your data. You don't want them to be kept by the vendor at the end or after the end of the contract, but at the same time, you want to make sure that you get your data back at the end of the contract. So there, the question is, when is deletion happening? Is this at the initiative of the customer, or is it at the initiative of the vendor? And how is that exactly regulated? Are there any data that need to be kept post-contract? And do you need any post-contract confidentiality obligations? Think about that. Do you want a right to audit, for example, at the end of the contract or after the end of the contract to check whether indeed your data have been deleted? And then last but not least here, of course, what is the cost and the pricing of all of the above? Better negotiate that when you enter into the contract than at the end, because at the end, you as a customer, you will be in a very in a situation with very little leverage over the vendor. Issue number 11 that I wanted to mention here on cloud contracts is the regulatory issues. And these are issues which may not be relevant for all of you, but are relevant when you are a company or an organization in a regulated sector. What I mean by that is, for example, banks, insurance companies, reinsurance companies, financial institutions, and so on. What is the issue? Well, cloud contracting, IT cloud contracting is considered as IT outsourcing. It may even be a material or critical IT outsourcing, which means that the rules on outsourcing will apply here, and that maybe there will even be an obligation to notify to the regulator, the national bank, the FSMA, or to even get some approvals. That's the first issue. The second issue from a regulatory point of view is there may also be specific rules on cloud computing. So even separate from outsourcing, there are rules on entering into cloud contracts more and more in the banking sector, in the insurance and reinsurance sector, and so on. So you will need to combine these rules to make sure that whenever you enter into a contract, you comply with the rules of outsourcing and cloud contracts. And the challenge is, of course, that here, in fact, there are two challenges. First of all, we come across sometimes companies in regulated sectors which have entered into cloud agreements, but never thought about oh, this is an outsourcing, this should have been notified to the regulator. Did we check whether the contract complies with what the regulator wants in this type of contracts? That's one challenge that we see. The other issue that we see often is when customers think about the regulatory issues, that is sometimes very difficult to convince the vendors, which are just selling a standard application under standard contractual terms, to convince the vendors that this is really an issue for the customer and that they should possibly make amendments to the contracts to accommodate the customer and ensure that the customer complies with applicable regulation. I will not go into the detail of these two slides, but I've inserted two slides, one slide on regulatory things or regulatory texts to think about in the insurance and reinsurance sector, and one about the banking sector. You will see that it's more or less the same. In the insurance sector, you have, for example, the royal decrees on where your insurance and reinsurance documents must be stored. That is relevant, especially if you are going to the cloud, where your data will no longer be under your control. There is the overarching circular on governance system, which contains the rules on outsourcing. There are recommendations on outsourcing to cloud service providers. There are guidelines on information and communication technology, security and governance, and so on. And you have the same in the banking sector. And the purpose here of today is not to detail and to explain all of these rules, but just to warn you, if you are working in, or if your organization is in a regulated sector, think about cloud contract may constitute outsourcing. There may be specific rules to cloud contracts applicable to my organization. So what exactly do you have to do? First of all, check whether it is an outsourcing or not under your outsourcing rules, depending on the sector in which you are working. Secondly, if it is, check your outsourcing policy and comply with your outsourcing policy, including governance, risk assessment, due diligence, documentation, and so on. Check also whether under your outsourcing rules it is a material or critical outsourcing. Check whether you need to notify the regulator, national bank, FSMA, and so on. Check also your contract, because once you are in a situation of regulated outsourcing, the regulations contain a number of minimum requirements for contracts. So you will need to check, and you do that preferably on the basis of a checklist that you have developed on beforehand for this kind of situations, but you need to check whether the cloud contract indeed complies with the minimum requirements for outsourcing agreements in your sector. And last but not least, check also whether there are no specific rules on cloud contracts, which you have, for example, in the banking and in the insurance sector. Impact of the B2B Act. You know that since a couple of years, we have now this B2B Act, which provides for a number of rules on unfair practices in a B2B context. I wanted to mention this here because it may be relevant, specifically because it may give you as a customer some ammunition in your negotiations with the cloud vendor. You know that the B2B Act contains a catch-all provision, which contains a general prohibition of contractual clauses that create a clear imbalance between parties. That's one issue. Secondly, there is a blacklist of clauses that are in any event per se prohibited. And third, there is a gray list of clauses that are deemed illegal and prohibited, but proof to the contrary can be provided. This is mandatory law. So I think it's very useful if you have any negotiations with a cloud vendor to look at this B2B Act and whether you cannot find any arguments and any clauses, any provisions that you can use to your advantage in your negotiations to convince the the cloud provider, the vendor, that the contract must indeed be amended on some or other point. And then the last issue is applicable law and jurisdiction. In fact, there is not so much to say about applicable law and jurisdiction. You will also have noticed that most of the time this is vendor imposed, meaning that you will have to agree to, for example, applying US law and going to California courts. It is indeed difficult to change, but I really think that it's not impossible. Most of these vendors, of cloud vendors, have operations worldwide, and they are in any event submitted to a whole series of different jurisdictions. So for them to change the applicable law in the contract is not really a significant inconvenience. That's the first issue. Second comment that I wanted to make on this is that sometimes you get a degree of choice offered by the vendor. So the vendor may be willing to or may have contracts in a number of different legal jurisdictions. For example, you can choose between Irish law, UK law, US law, and so on. For public authorities, there are sometimes restrictions on agreeing to applying foreign law. So also take that into account if you are in that public sector. If foreign law applies, of course, a high-level review by a foreign counsel is recommended. I think these are, and I see that we are a little bit over time, but I'm ready to conclude this webinar. These are, I think, the 13 most important issues from my point of view in cloud contracts. Now, I wanted to conclude and to give you a bit a flavor or an idea of how you can work with this from a practical point of view. And my advice here would be, as here stated on the slide, pick your battles. Not everything is worth flipping out over. You will really have to choose on what points you want to really negotiate the cloud contract. So you are faced with, as I said, contracts of adherence, limited room for negotiation due to absence of leverage and also the nature of the service, to be honest. So you will indeed have to pick your battles. And how do you do this concretely? Well, my recommendation is also always, and I've put that also in the invitation for this webinar, I've said starting to make a whole markup of the contract is probably not worth doing. What do you have to do? Well, you have to use a risk assessment approach. First of all, you have to understand the contractual framework. That's the first issue. Secondly, analyze the contractual framework from a risk perspective. What do I mean by that? Is that you review the contractual framework, you analyze each important clause, and you score it vis-a-vis your own organization's risk appetite. And you can do that with red, yellow, green, and say, okay, on liability, we are, for example, red. We are far from what we would normally accept. But on this other issue, for example, data ownership, this is more or less okay. This is maybe yellow, or it may even be green. So make an analysis of the contract, make an assessment of the contract, of all the important clauses of the contract, and then pick the battles that you want to do and concentrate the negotiations on what is really important. For example, if you are in a regulated sector, regulatory compliance will probably be very important for you. So choose the items that you really want to negotiate. After negotiation, you redo the analysis and the assessment. You also try to document that, and you see where have you come out after the negotiations. Have you improved your position? Have the red items, for example, the items that were flagged red, have they become yellow or green? And make an assessment over the entire contract and provide internal advice on the basis of this full assessment of the contract. It is very important, I think, and I'll come back to that, and that's also why I explained what is cloud at the very beginning. It is important to understand that cloud is not a customized on-premise solution, so you will not be able to have everything that you want. It's based on a trade-off, economies of scale versus on the other hand, having all that you want on-premise environment. So that's really the key issue. I would like to conclude this webinar now, thanking you all for your attention. As I said, there are some questions that have come in. We will get back to you, to those who have asked questions by a separate email after this webinar. I thank you very much for having attended this webinar. I hope that this was useful for you. If you have any questions on this, please feel free to contact me. You will also find in the slides at the end a bit an overview of what we, Lydian, and our ICT department can do for you, review of contracts, negotiation, and so on. Thank you very much and have a very nice afternoon.